Good morning. Let the record reflect the jury seated, state's attorneys present, defendant and defense counsel are present. So at this time, ladies and gentlemen, I am required to read the entire court's charge to you. So here we go. Cause numbers 24 DCCR 0917 and 24 DCCR 0918, the state of Texas versus Dalton Batiste. Jury instructions. Members of the jury. The defendant, Dalton Batiste, stands charged by indictment in each case with the offense of murder. The defendant has pleaded not guilty, and you have heard all the evidence in each case. The parties will soon present final arguments. Before they do so, I must now give you the instructions you must follow in deciding whether or not the state has proved the defendant guilty in each case. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases. Then I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable in this case. General principles. The indictments are not evidence of guilt. The indictments are documents required to bring the case before you. Do not consider the fact that the defendant has been arrested, confined, indicted, or otherwise charged. Do not draw any inference of guilt from any of these circumstances. The defendant is presumed innocent of the charges. All persons are presumed to be innocent, and no person may be convicted of an offense unless the state proves each element of the offense beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all. You may find the defendant guilty only after a careful and impartial consideration of all of the evidence, and only if the state has proved the defendant's guilt beyond a reasonable doubt. The state has the burden to prove every element of the offense beyond a reasonable doubt. If the state proves every element of the offense beyond a reasonable doubt in each case, then you must find the defendant guilty in each case. If it does not, then you must find the defendant not guilty. If, after you have considered all the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty in either case, you must find the defendant not guilty in that case. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with this case that is not evidence in the trial. Statements made by the lawyers are not evidence. The questions asked by the lawyers are not evidence. Nothing I have said or done in the cases should be considered by you as my opinion about the facts of the cases or influence you to vote one way or the other in either case. You should give terms their common meanings, unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence, you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the cases under the law that is in these instructions. Do not allow your verdicts to be determined by bias or prejudice. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Certain testimony will be read back to you by the court reporter if you request. To request that testimony be read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. That request must, 1, state that it is requesting that testimony be read back. 2, State that you have a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identify the name of the witness who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. The law requires that you render a verdict of either guilty or not guilty in each case. The verdict of not guilty simply means that the state has not proved the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict in each case. When you reach a verdict in each case, the foreperson should notify the court. The defendant has a constitutional right to remain silent. The defendant may testify on his own behalf. The defendant may also choose not to testify. The defendant's decision not to testify cannot be held against him, and it is not evidence of guilt. You must not speculate, guess, or even talk about what the defendant might have said if he had taken the witness stand, or why he did not. The foreperson of the jury must immediately stop any juror from mentioning the defendant's decision not to testify. During the trial, you heard evidence that the defendant may have committed wrongful acts not charged in the indictment. The state offered the evidence to show absence of mistake and knowledge. You are not to consider that evidence at all unless you find beyond a reasonable doubt that the defendant did, in fact, commit the wrongful act.
Right here, the judge sets the stage. This isn't just a formality. Every word defines how the jury must think. And notice not guilty isn't proof of innocence. It's a declaration that the state has to prove guilt beyond all doubt, classic cornerstone of criminal law.
Those of you who believe the defendant did the wrongful act may consider it. Even if you do find that the defendant committed a wrongful act, you may consider this evidence only for the limited purpose I have described. You may not consider this evidence to prove that the defendant is a bad person and for this reason was likely to commit the charged offense. In other words, you should consider this evidence only for the specific, limited purpose I have described. To consider this evidence for any other purpose would be improper. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing argument by the attorneys, you will go into the jury room. Your first task will be to select your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other jurors on the verdict, and sign the verdict sheet in each case. While deliberating and until excused by the trial court, all jurors must follow these rules. 1. You must not discuss the cases with any court officer or the attorneys or anyone not on the jury. 2. You must not discuss the cases unless all of you are present in the jury room. If anyone leaves the room, then you must stop your discussions about the cases until all of you are present again. 3. You must communicate with the judge only in writing, signed by the foreperson, and given to the judge through the officer assigned to you. 4. You must not conduct any independent investigations, research, or experiments. 5. You must tell the judge if anyone attempts to contact you about the cases before you reach your verdict. Your sole duty at this point is to determine whether the state has proved the defendant guilty in each case. You must restrict your deliberations to this matter. After you have arrived at your verdict in each case, you are to use the forms attached to these instructions. The foreperson should sign the line that corresponds to your verdict in each case. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict in each case. Relevant statutes that apply in both cases. Section 19.02b4 Texas Penal Code. A person commits the offense of murder if he knowingly manufactures or delivers a controlled substance included in penalty group 1B under section 481.1022 Health and Safety Code in violation of section 481.1123 Health and Safety Code, and an individual dies as a result of ingesting, inhaling, or introducing into the individual's body any amount of the controlled substance manufactured or delivered by the actor, regardless of whether the controlled substance was used by itself or with another substance, including a drug, adulterant, or diluent. Section 481.1022 Health and Safety Code. Penalty Group 1B consists of the following opiates, including their isomers, esters, ethers, salts, and salts of isomers, esters, and ethers, and salts, if the existence of these isomers, esters, ethers, and salts is possible within a specific chemical designation. Fentanyl, alpha-methafentanyl, and any other derivative of fentanyl. Sorry, those words are apparently hard for me to say. Section 481.1123. A person commits an offense if the person knowingly manufactures, delivers, or possesses with intent to deliver a controlled substance listed in Penalty Group 1B. Delivery of a controlled substance. A person commits the offense of delivery of a controlled substance if the person knowingly delivers a controlled substance by actual transfer or constructive transfer. Fentanyl is a controlled substance. A person delivers a controlled substance to another by actual transfer if the person has possession and control over the controlled substance and manually conveys that possession and control of the controlled substance to the other or to an agent of the other person. A person constructively transfers a controlled substance to another if the person had either direct or indirect control of the transferred substance before delivery and knew that it would be delivered to a transferee. Definitions. Knowingly. A person acts knowingly or with knowledge with respect to the nature of his conduct or to circumstances surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. Adulterant or diluent means any material that increases the bulk or quantity of a controlled substance, regardless of its effect on the chemical activity of the controlled substance. Deliver means to transfer actually or constructively to another, regardless of any agency relationship between the other person and any other individual. And so that all applies to both cases. Now you're going to have two different sections, one for each of the cases. The cause numbers are at the top, separating them so you'll be able to tell which one's which. The first, cause number 24 DCCR 0917, law specific to this case.
This line often surprises people. The defense doesn't have to prove anything. The entire weight rests on the state. Do you think that's fair, or should both sides have equal responsibility to prove their case?
The state accuses the defendant of having committed the offense of murder. Application of law to facts. You must determine whether the state has proved beyond a reasonable doubt three elements. The elements are that 1, the defendant, Dalton Batiste, in Jefferson County, Texas, on or about January 10, 2024, delivered by actual or constructive transfer a controlled substance included in Penalty Group 1B, namely fentanyl, and 2, an individual, Aaron Sanchez, died as a result of ingesting, inhaling, or introducing into his body any amount of the fentanyl delivered by the defendant, and 3, the defendant did this knowingly. You must all agree on elements 1, 2, and 3 listed above. If you all agree the state has failed to prove beyond a reasonable doubt any of elements 1, 2, or 3 listed above, you must find the defendant not guilty. If you all agree the state has proved each of the 3 elements listed above, has proved beyond a reasonable doubt each of the 3 elements listed above, you must find the defendant guilty. And then that has my signature at the bottom, and then you have the verdict form for that case. Cause number 24, DCCR 0917. It's titled, the top part, verdict, not guilty. We, the jury, find the defendant, Dalton Batiste, not guilty, and there is a line for the signature and then a line for the printed name of the foreperson. And then below that, verdict, guilty. We, the jury, find the defendant, Dalton Batiste, guilty of murder as charged in the indictment. Again, signature line and a line for the printed name of the foreperson. Then you go to cause number 24, DCCR 0918. The state accuses the defendant of having committed the offense of murder. Application of law to the facts. You must determine whether the state has proved beyond a reasonable doubt 3 elements. The elements are that
This is where it gets serious. The judge is warning jurors, you can't say he's a bad guy, so he must have done this. That's emotional reasoning. And it can flip a trial on its head. The state has to win on evidence, not character assassinations.
1. The defendant, Dalton Batiste, in Jefferson County, Texas, on or about January 10, 2024, delivered by actual or constructive transfer a controlled substance included in penalty group 1B, namely fentanyl, and 2, an individual, Matthew Christ, died as a result of injecting, ingesting, inhaling, or introducing into his body any amount of the fentanyl delivered by the defendant, and 3, the defendant did this knowingly. You must all agree on elements 1, 2, and 3 listed above. If you all agree the state has failed to prove beyond a reasonable doubt any of elements 1, 2, and 3 listed above, you must find the defendant not guilty. If you all agree the state has proved beyond a reasonable doubt each of the 3 elements listed above, you must find the defendant guilty. Again, that has my signature, and then you have the verdict form for that case, 24 DCCR 0918. The top, verdict, not guilty. We, the jury, find the defendant, Dalton Batiste, not guilty. Signature line in line for the printed name of the foreperson. And then below that, you have verdict, guilty. We, the jury, find the defendant, Dalton Batiste, guilty of murder as charged in the indictment. Again, signature line in line for the printed name of the foreperson. All right, Mr. Coleman, the state has the right to open and close closing arguments.
This time the state would waive its right to open, but reserve its right to close.
Thank you, Mr. Coleman. Mr. Gertz, you may proceed.
Yes, Judge, may I have a moment to get set up?
Yes, and with y'all's permission, I'm going to make the adjustment to those numbers that were messed up on page 8.
Thank you.
Thank you. No matter how many times we go over this, there's always something I find when I read it out loud.
Well, good morning, ladies and gentlemen. Thank you very much for your participation in this process, your willingness to listen to the evidence, the testimony, and consider this very important case. Before I talk with you about what we think the facts were and were not proven in this case, I'd like to talk to you a minute about your role as jurors. So I would suggest to you that you've actually won the citizenship lottery by actually making the jury and getting to be on the jury, because you're getting to participate in this amazing process that we have that lots of other places do not have. And jurors in this county make some of the most important decisions that you can make. Across the hall down there, they make decisions about taking money from one party and giving it to another. They make decisions in family court of who's going to get the children in a custody dispute, or maybe get their children taken away from them by the state. And in the chairs that you're sitting in, I submit to you that jurors make the most important decisions that you can make as a jury, and that is about people's liberty and about their lives.
The judge is locking the jury into their mission, no outside thoughts, no sympathy, no bias. Imagine the pressure, 12 strangers deciding whether a man spends his life in prison or walks free purely by the book.
And so I appreciate you. Dalton Batiste appreciates you. His family appreciates you. And you listening to this evidence in this case and these instructions, and hopefully following them and following the evidence in the case. And the judge told you one of her instructions is that your sole duty is to determine whether the state has proved the defendant guilty in each case. And I would submit to you that while that may feel like a collective task, it's actually an individual task that you have. And I talked to you in jury selection about each of you starting the case with an empty backpack. And this is where that comes home for you. Each of you individually needs to be satisfied that the government has filled up your individual backpack with believable, truthful, credible evidence. And if they have neglected to do so, if they have not satisfied you individually, your oath requires you to vote not guilty and to persist in that vote. And I would submit to you that if you find yourselves at an impasse, please, 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 if your backpack is not full, do not give way if you are not satisfied that they have proven each and every element of this case to you beyond a reasonable doubt. Now, the other thing you need to know about this process is that the buck stops with you. You can't come back next week and say, hey, Judge West, I actually had a doubt. I had a reasonable doubt. But I was persuaded, or I was forced, or I was told we can't go home until we, get this thing wrapped up. And so I gave up on it.
This metaphor is powerful. Think of those 3 locks as evidence gates: delivery, death, and knowledge. If even one lock doesn't open, meaning the evidence doesn't fit, the case collapses. It's all or nothing. And now we hit the moment of truth. The defense steps up to challenge the chain of proof. Did the prosecution really connect every link, or did something critical slip through? Stick around, this next part could flip the entire case.